Dear ladies and gentlemen, Joy Stephen from the Paulinsis Studios, and here is another case law for the Student Herald. Canada versus Alsha'bi. Now, case laws are not meant for people who are interested to apply for permanent residence to Canada, but may be used by those who feel the system may not be fair or to gain an understanding of the recourse available in Canada for a negative decision. Content for this video is sourced from information distributed by Thomson Reuters. Judgment for this case is attached in my blog, reportersreport.com, as a PDF document. This is an immigration case law and includes topics like refugee status, procedure, appeal. New evidence. Refugee claimants were mother and two children who were stateless Palestinians. Refugee claimants and father had apparently lived in Syria before moving to UAE, or the United Arab Emirates, as temporary residents since 2001. Refugee claimants allegedly feared being forced to return to Syria even though father was able to maintain his employment. Refugee claimants possessed Syrian travel documents when they came to Canada in 2014. Refugee claimants unsuccessfully applied for refugee status. Refugee claimants successfully appealed to Immigration and Refugee Board's RAD, or Refugee Appeals Division. RAD accepted new evidence from January 2015 showing UAE Ministry of Interior had cancelled refugee claimants' residence permits. RAD concluded refugee claimants would be at risk of being removed to Syria if they returned to UAE. Minister of Citizenship and Immigration brought application for judicial review. Application was dismissed. Minister failed to establish reviewable error. RAD had not erred in accepting evidence confirming cancellation of refugee claimants' UAE residence permit. Documents establishing cancellation had been issued by UAE after rejection of refugee claim. This evidence had not been reasonably available at time of initial hearing, and refugee claimants could not have been reasonably expected to present it. Since initial decision has been based on refugee claimants being able to return to UAE, cancellation was materially different fact that gave rise to different decision. While scope of RAD's appellate powers was still uncertain, RAD had not exceeded its powers. RAD had made decision based on existing record and new evidence as it was permitted to do so. Interesting case, Canada versus Alsha'bi. It's dated December the 14th, 2015 from the Federal Court. Thank you.